Hey everyone, and welcome back to the University. Today we have day 6 of the Raymond Davis trial. This is the Doggett hearing that took place on July 30th, 2019, and it includes the entirety of the case. That's why it's so long. It's approximately 2.5 hours long. And here we get to see a lot of what went into how he was arrested, and you get to see your first Raymond outburst. He really just can't contain himself, can he? All right, I hope that you enjoy.
All rise. District Court Department 6 is now in session. The Honorable Jacqueline M. Luke presiding. Please be seated and come to order.
Right. 1 second, guys. All right, so we're on the record in C340075, State of Nevada versus Raymond Davis. Mr. Davis is present out of custody with Mr. Mueller and Mr. Maynard. On behalf of the state is Ms. Collins. This is the time and date set for the evidentiary hearing pursuant to the defendant's motion to dismiss under Doggett versus United States. Are both sides ready to proceed with the hearing?
State answer.
Defense?
Defenses.
All right. So, Ms. Collins, did you want to call your first witness?
I would like to, thank you.
All right.
State Call Sergeant Sean Beck.
Okay.
Remain standing and face the court.
Please raise your right hand. You solemnly swear the testimony you're about to give this action be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated. Please state your complete name, spelling both your first and last name for the record.
For the record, Your Honor, it's a detective, not sergeant.
Oh, okay.
Sean, S-E-A-N, Beck, B-E-C-K, P number 6275, Detective, Las Vegas Metropolitan Police Department.
Thank you.
My apologies, Detective, thank you. Sir, how are you employed?
Detective, Las Vegas Metropolitan Police Department, and Task Force Officer, FBI Criminal Apprehension Team Task Force.
And what do you do in that capacity?
We are assigned to locate and apprehend subjects wanted for violent felony offenses.
How long have you been employed in that capacity?
I've been a police officer with LVMPD since 1990, so over 20 years. I've been with the Major Violator Section and its predecessor, the Career Criminal Section, for over 10 years.
Do you work in squads within that unit?
Yes, ma'am. The Major Violator Section is comprised of 3 squads of detectives, each supervised by a sergeant. My particular assignment is with the Joint Criminal Apprehension Team Task Force.
When subjects, when warrants are issued for the arrest of certain subjects, is that your team's responsibility or the sister or brother squads to pick those people up?
Yes, ma'am. All 3 squads are assigned to locate and apprehend wanted suspects. Since Sheriff Lombardo was elected and heads up the organization, all of our resources have been leveraged towards violent crime, particularly violent gun crime. Our squad in particular, the Criminal Apprehension Team Task Force, we're responsible for homicides, attempted murders, other violent batteries involving deadly weapons, robbery series, and sexual assaults.
How are cases assigned amongst the squads?
So there are a few ways that a case may find its way to any of our squads, or our squad in particular. Approximately 120 cases a week are arrest warrants, felony arrest warrants, are issued out of the Justice Court Administration. So one of our detectives every week goes over to Justice Court Admin, and we pick up that approximate. And I'm just approximating. I've been on the squad for about 5 years, and it's usually around 120 cases a week. From that, our investigative specialists will review those cases, and the cases that I just described to you a moment ago, homicides, attempt murders, armed robbery series, and sexual assaults will be pulled from that number and assigned to the detectives on my squad. And so that turns out to be about 3 to 5 new arrest warrant assignments per week.
Per week per detective?
Correct. And there are 5 Metro Police detectives assigned to the task force, supervised by a sergeant. The sergeant doesn't take cases. And there's another route that cases find their way to us. Being part of the FBI Criminal Apprehension Team Task Force, we also are charged with serving federal arrest warrants with our task force partners. We're also responsible for locating and apprehending fugitives from other jurisdictions who have sought assistance through the FBI that are believed to be located in our jurisdiction. And then, of course, we coordinate with task force partners and other agencies nationwide and overseas to try to return fugitives from our jurisdiction back to Clark County for prosecution.
So that's in addition to your normal assignments that come through Clark County Justice Court?
That's correct, in addition to, ma'am.
Now, in the course of your attempts to locate these individuals, are you called to other assignments and other cases given priority on a routine basis?
Yes, ma'am. A perfect example would be if homicide were to identify a perpetrator of a homicide, and they either obtain a warrant for their arrest or there's ample probable cause to effect an arrest in that case. They'll reach out to us directly. We'll get a briefing from them, and then we'll proceed with locating and apprehending that subject. And it becomes an issue because everybody stops what they're doing. The entire team stops what they're doing and starts working on that one case. In this case, a homicide is my example, until that perpetrator is taken into custody. Sometimes that can be hours, it can be days, sometimes it takes weeks. In all the other cases, they become secondary until that principal case is resolved.
And is that routine for that to happen?
Yes.
And the other cases, like you said, are then set aside for those priority cases as they come out?
That's correct.
And we're talking about a 5-detective squad and 1 sergeant who does not maintain a caseload or does not participate in active apprehensions.
That's correct. So in preparation for today's hearing, as of last Friday, there were 502 active felony arrest warrants assigned to the 5 detectives in my squad. So that equates to roughly 100 cases per detective. Those are just the cases that came from the justice court through normal course. It doesn't take into account the other cases that I described that come up. At present, 2018, the entirety of the section, so not just my squad, but all 3 squads assigned to the major violators section, made 602 felony arrests last year, 2018. So juxtapose those numbers, cases per detective, cases actively assigned to our team, 502, and then the entirety of 3 squads' work last year was 602 felony arrests.
Focusing your attention on 2016, did you have a partner?
Yes.
And who was that partner?
Detective Giannoni.
Did you and Detective Giannoni, or Detective Giannoni specifically, he's no longer employed by Metro, I guess I should.
That's correct. He technically wasn't my partner. We each work our own individual caseload and then come together as a team when it's necessary. But yes, we did work together at that time.
And I misspoke, I'm sorry, he was on your team at that time.
That's correct.
To your knowledge, were you assigned, and when I say you, I mean your squad, were you assigned an arrest warrant for one Raymond Davis?
In preparation for today's hearing, I did consult an archived version of that assignment roster, and the answer to that question is yes, he was assigned to that case.
And would have that been on or about October 3rd of 2016?
I believe so.
Is it your practice to verify that warrant is entered into NCIC before you do anything?
When I receive a case, I'll take a look at the surface of the case, if you will, and try to determine whether or not that person may have fled the jurisdiction based on any information that I may have gotten from the investigating detective or reports associated with it. If that was the case, if I thought there was a chance they had fled the jurisdiction, then I would make sure that it had been either placed into NCIC by the investigating detail or through or our investigative specialists after consulting with the district attorney's office to ensure that there would be authorization for extradition.
is it fair to say that you sort cases by solvability?
Absolutely, ma'am. Like I said, if homicide were to call and they've got information that is immediately actionable, and or any other detail for that matter, then we're going to prioritize that case first and take action based on those solvability factors. We've got to be efficient with our time, as you can imagine, given the situation that I just described to you.
Sorry, may I have a point of clarification, Ms. Collins? When you say solvability, do you mean ultimately on the merits of the case, or just
No, I
finding
mean
somebody?
solvability in terms of apprehension. I apologize.
That's okay, just checking.
That's right.
And maybe I should clarify, when I say solvability, I'm talking about good intel that's going to lead you to a relatively quick arrest.
Yes, that would be an accurate description. I wouldn't qualify it with fast. At present, I personally have 2 cases from the Justice Court. They're in 2 different jurisdictions, and so. Ask me the question again. I apologize.
Okay, let's go let you finish your answer.
The solvability, or, yeah.
Thank you, Judge. If I got 5 cases this morning, one was for a robbery with a deadly weapon, one's attempt murder with a deadly weapon, 3 are for various sexual assaults, including sexual assault against a minor or sexual assault against against an adult. 2 of them would likely be with Hispanic surname with no social security number and an XID number, which means the identity of that person is in question. I do database searches to try to backstop that identity, determine whether or not they have an A number, have they been encountered by ICE, crossing illegal, etc. My point the reason I point all that out is that if you can't backstop that identity, it becomes very hard to locate that person. So solvability, as we were using as a word, is the ability to locate and apprehend them is what we're talking about. You know, the case is valid, a judge has issued a warrant for that subject arrest. Now, what are the factors, what is the intelligence, what information is available that we can try to dig up to go out and find that person and bring them before the court judge?
The name of the gentleman on your squad was?
Detective Giannotti.
Giannotti. I'll get it right. Do you know what actions he took to locate Raymond Davis?
I do not, ma'am.
Were you present for any arrest that was made or any interaction with Ray Davis?
No, not to my knowledge.
That's the witness.
Okay.
Detective, I'll just make sure I understood things. You've got 3 squads, 5 men each.
My squad has 5 detectives supervised by a sergeant, and then there are 2 additional Metro squads assigned to the section that are also supervised by a sergeant. They have between 4 to 6 members, generally speaking, depending on folks that are on admin leave or office.
So we're getting, by all accounts, and I don't want to put words in your mouth here, I'll make sure I wrote these numbers down correctly. You said you get 120, give or take, and I understand at times, busier or slower, 120 felony arrests,
Warrants.
out of Justice Court per week.
That's correct. 120 Justice Court warrants, arrest warrants come out of Justice Court admin. And from those approximately 120 a week, our investigative specialists categorize those warrants based on crimes of violence and make those assignments to our team, and then the remainder of those go to the remaining teams in the section.
I understand, sir. So about 5,000, give or take, is the volume a year.
I'll stipulate to that.
Okay, fair enough. Now, you said you were actually brought up twice, you mentioned twice that in 2018, the last complete calendar year, you and your squads and teammates had located 602.
Correct.
Now, I don't mean to be unduly harsher, but the math indicates that you're getting about 30% of the warrants every year?
That's about right.
Okay. Now, there comes a time when you're managing something where you do the easy stuff and that pays off first. Now, I understand you got to go after violent murderers and the priorities are what they are. But you said solvability. Do you remember that phrase?
Yes.
That was actually your phrase, solvability.
Sure.
Now, I don't want to go out on a limb here, but I imagine your duties in a certain way just become a job. Everybody's function eventually becomes a job. You do it the standard way, you do things the standard routines, correct?
I'm gonna object, vague.
Okay, I'm getting to the
Just
point.
clarify.
Sir, do you have access to the state's databases?
Yes,
Okay, so you can run somebody's driver's license, correct?
yes, sir.
Now, if somebody doesn't have an extensive criminal record and there's no reason to believe they're fleeing, you can just go to their house, correct? If, assuming they've got a current driver's license address on it.
Well, the key phrase there is assuming that they're living at that address. I've encountered many subjects that have different, that live at different places other than what's on their driver's license.
Yes, sir, I understand. I do some work in front of the DMV as well, but I understand. You have access to the DMV
Yes.
database. Now, you also have access to the state's voters rolls, correct?
I don't believe I have access to that, sir.
Well, do you go over, check with the jury commissioner?
I'm sorry, was that a
You
question?
ever check with the jury commissioner?
No,
You've
sir.
got okay, do you know where they get their names and addresses from?
I only have access to one database that has access to voter information, and we're not allowed to, when we sign up for that database, we have to check the box that does not access that information.
All right, let me ask you a question, sir. When you get a warrant, you get the police report with it? I officer 1200 P number was summons to 123 Main Street. You get those police reports?
I would have to sit down and go through either our on-base or our P1 system and pull that out myself.
All right, so the police report would in fact frequently have the address of where the police were summoned to.
Are we talking about a specific case here, or?
In general, sir, you're trying to get 5,000 people a year, or at least doing your best. I mean, if someone was summoned to the house where the officer found an illicit gun or drugs, going to the house where the person lived would be a logical place to start, wouldn't it?
So first, if it was my case and it was assigned to me, then I would most probably pull the arrest warrant, pull the declaration of warrant if the case was in warrant, and probably take a look at the arrest report if there was an arrest report. But again, this case wasn't assigned to me, so I can't speak to any specific actions that were taken or weren't taken with regards to locating and apprehending the defendant.
All right, sir. And the fellow who used to work with in this section, he's no longer with Metro?
That's correct, sir. He's retired.
Retired, God bless. Now, did you have his notes? Did he have any case notes?
I do not have his case notes, sir.
Did he retire as in gone fishing down in the Adirondacks somewhere, or is he actually still in town?
I haven't spoken to him since he retired, sir.
Okay, so he's gone, not one of those partial retirements.
Again, sir, I haven't spoken to him since he retired.
Okay. Now, did you look at his notes? Did he have a note on Mr. Davis's file?
No, the case is not assigned to me, sir.
Okay. Did you, at the request of Ms. Collins, go pull his notes, or do you guys keep a file?
I did not.
All right. Now, when you personally are looking for somebody, do you actually make notes? I checked with the Dairy Queen, he's no longer there. I went to the St. Tropez Apartments, he's no longer there. Do you keep track of where you look for somebody?
Yes, sir. If that case was prioritized in my priority of work and within the scope of the totality of the squad's operation on a given day, then yes, those would be reasonable things that I would do.
All right. And did you check to see if there was any notes filed for Mr. Davis?
No, sir.
All right. Have you ever used a jury summons, sir?
I've been served a jury summons before, but
Yes, sir. But have you, as part of your job of locating suspects or warrants, have you actually just looked someone up to see if they're a registered voter?
no, sir. I think I was very clear that I indicated I haven't done that before.
Now, the soul of law enforcement is actually prioritizing, correct? Officer discretion in the field?
Well, there are many factors that come into play with regards to prioritizing cases. Supervision, visibility, community impact, visibility by the command staff, any number of factors.
Yes, sir. I know that's why the law allows officers broad discretion in enforcing the law. But you would agree that you also and your squad also has broad discretion in which warrants to pursue and which ones not to.
I think that's accurate, yes, sir.
All right. Now, and I want to physically understand this. Is there a file room with warrants physically there? Or do you just have a computerized spreadsheet?
For our squad, we track the case assignments, the ones that come from justice court specifically, on a spreadsheet, sir.
So you got it all on a spreadsheet?
Yes, sir.
Okay. So on the spreadsheet, do you have the date the warrant was issued?
Yes.
Do you have the last known status of the effort to try to locate that person?
I believe that I don't think so.
You don't think so? Does it indicate if any effort was made to, any effort at all? Now, there are times and places where you guys make no meaningful effort to find the suspect, correct?
Objection, argumentative.
Well, it has to be, okay, let me
Just
rephrase.
just rephrase the statement.
Okay. Sir, if you get 600 a year and there's 5,000 issued, there's a backlog of warrants building.
No, that is the practical reality with regards to the amount of resources that we have and the number of unserved arrest warrants that are out there. Yes, sir.
Okay, so the bucket's got a smaller hole in the bottom than it does at the top.
Yes, sir.
The number, and currently, the number of warrants is backlogged.
Correct.
All right? Now, did anybody from your squad make any effort to find Mr. Davis that you know of?
I don't know the answer to that question, sir.
Sir, you have served as a detective, and you would agree that evidence spoils with time, correct?
I think it's case by case and based on the facts and circumstances of that particular case. That'd be a broad statement to apply.
Would you rather be at a crime scene immediately after the crime or a couple weeks later? You're a detective.
It's just not my role. My role is to locate and apprehend, not to conduct the initial or follow-up investigation.
Yes, sir. But as a simple proposition, everyone in this courtroom here has extensive criminal law experience. We all know that the older a case gets, the harder it gets to solve, correct?
Sure.
All right, you would agree with that proposition?
I believe that given the facts and circumstances of a specific case, that could be a problem, yes.
Now, as a detective, human memory, is that a good piece of evidence or a bad piece of evidence?
Your Honor, I'm going to object to the scope of this hearing.
Say the last part of the question again.
Sir, physical, I'll rephrase, Judge. My colleague makes a point. I'll rephrase it with the court's permission. Sir, physical evidence. You can collect it at the scene, correct?
Yes.
All right, it doesn't lie, doesn't have any motive, it's evidence.
Same objection, Your Honor.
I do think we're getting a little far in regards to the scope of this hearing.
Certainly. All right, one last question and I'll sit down. Sir, have you had people whose memory has faded with time?
Yes.
Is that a very common phenomenon in law enforcement?
It's not uncommon.
Not uncommon. Can I get the court's indulgence for just a moment?
Sure.
Sir, how many warrants are unsolvable?
I don't know the answer to that question.
All right, do you have a management tool in the squad to say, this is Jose Gonzalez with no information, we're not going to make an effort to solve this one?
I would never say that we would deliberately not make an effort to effect an apprehension in the face of a warrant signed by a judge. But again, I would go back to my earlier statement where the work has to be prioritized based on solvability.
Okay, and how many warrants go 2.5, 3 years?
I don't know the answer to that question, sir.
Okay, and just one last question. Did you or anybody in your squad, could you have any evidence that anybody went and just knocked on Mr. Davis's door?
I do not have that information, sir.
All right, I have nothing further.
Ms. Collins, redirect?
If during your initial screening to kind of ascertain whether you're going to be able to apprehend someone, if you run a DMV and you get an out-of-state driver's license, what does that tell you?
That'd be an early indication that the subject may possibly flee to another jurisdiction to avoid arrest and prosecution.
Did you run any of the DMV available for Ray Davis?
I did not participate in the attempt to locate and apprehend the defendant.
And I should have followed up on this when you spoke about it earlier. You said you made contact with the district attorney's office regarding extradition.
Correct. There are certain categories of felonies that qualify for being entered into NCIC with full extradition. Some of those cases my investigative specialist can look at a list of those crimes and make the determination and enter them into NCIC without coordination from the district attorney's office. In other cases, if they're not on that list, then I would probably refer to the investigative detail from where the case came from and have them work with the district attorney's office to get that case approved for extradition and into NCIC, ma'am.
So a determination is made prior to its entrance into NCIC III about whether a law enforcement entity will extradite, whether it's us or the AG's office. Somebody decides whether they're going to extradite or not.
Sometimes we'll get cases that are already entered into NCIC, and sometimes we will get cases that are not already entered into NCIC, and then we have to follow up either entering them ourselves with the criteria that our investigative specialist has in a binder, or we'll refer it back to the investigative detail to obtain permission to extradite from the DA's office and then put it in NCIC.
If you have a no extradition or in-state only warrant coupled with an out-of-state driver's license, is that going to change generally the efforts that your team takes to locate someone? If you believe somebody's in another state and their III NCIC warrant is reading in-state only, is that going to alter your efforts to go out and look?
Oh, absolutely.
Are you familiar with when this case was entered into III?
No.
Okay, thank you. Nothing else.
Can you clarify from what Ms. Collins is saying, well, how would it affect it? If you have an in-state warrant only and an out-of-state ID, how does it affect how you will look at the case, or how you should go about doing it?
Yes, Your Honor. Well, it would require additional communication between whoever the detective is assigned to locate and apprehend on our side with the investigative detail or the investigating detective that put the case together with regards to whether or not that case is a case that is eligible for extradition, and can we get it from no X or in-state only to full X or not. And that could be based on a number of factors that could originate from either the classification of the crime or if there were any issues with the case.
So basically, it just means you have to start a communication with the officer, the submitting officer, to get some dialogue going in regards to, hey, can we move this from in-state only to out-of-state?
Yes, Your Honor.
Okay, got it. Thanks.
One more question based on that, all right?
Okay.
In terms of prioritizing warrants, if someone is, no, strike that.
Okay.
Sorry.
Mr. Mueller, anything based on that?
Just a few things. Sir, do you have access to power bills?
We could obtain information from various utilities through administrative subpoena.
Okay. Next question. If you are overwhelmed by a factor of 6, 4 to 5, you've got 1/5 of what you need, do you ever just send out the submitting detectives to go pick people up?
I don't make assignments to detectives. I'm a detective myself. I'm a peer detective. I don't tell other detectives how to manage or handle their case.
Yes, sir. My point is simply, you look, Bill, Bob, your buddy used to work with patrols, now work at different squads. You say, hey, we're not going to get to this warrant. This guy you popped or you wrote the warrant on. Can you swing by his house and maybe pick him up? Do you ever use it as the screening detectives to go pick, or submitting detectives to go pick people up, or ask them if they know anything where they're bad?
If I was assigned the case, I would look to have communication with the investigating detective. But as you said, given the enormity of the number, it's not always possible.
All right. And in this instance, we have no records anywhere of efforts to find Mr. Davis.
I'm not aware of any, sir. I'm not saying that they don't exist.
I understand, sir. All right, thank you. I'd like further.
Ms. Collins, anything based on that?
No, ma'am.
All right. Detective, you're free to go. Thank you so much.
Thank you, Your
Excuse me, Ms. Akita.
Thanks, Detective. State Ghost Detective Arturo Martinez.
Hi, good afternoon.
Remove standing, please, please raise your hand. You solemnly swear the testimony you're about to give this action will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Please state your complete name, spelling both your first and last name for record.
My first name is Arturo, Arturo, and Martinez, Martinez.
Thank you.
Ms. Collins?
Thank you. Good afternoon, Detective. How are you assigned?
I am currently employed with the Las Vegas Metropolitan Police Department as a sexual assault detective on the
How long?
juvenile side.
How long have you been an SA detective on the juvenile side?
I think a little over 2 years. Altogether with the sexual assault unit, about a little over 4 years now.
Are you familiar with the case regarding Raymond Davis?
Yes,
Do you see him here in court today?
yes I do.
Could you ID him for the record?
He's a gentleman wearing the green t-shirt, green sweats, with a green backpack laid next to his left side.
May the record reflect identification of the defendant.
Ew.
When did you begin investigating this case that we're here to discuss today?
I was assigned this case July of 2015.
And through the course of your investigation, interviewing witnesses, did you eventually submit for an arrest warrant?
Yes, I did.
When did you submit for that arrest warrant?
I believe I submitted it September of 2016.
And do you know when that arrest warrant was issued?
I believe it was issued September of 2016.
So the same month you submitted it?
I believe so.
Was it eventually assigned to the criminal apprehension team?
Yes, it was.
And do you know when that assignment was made?
I believe it was October of 2016.
Are you familiar with the case being entered into NCIC?
Yes.
And do you know what date that was?
I think it was May of 2017.
Show Mr. Mueller what I anticipate marking as state's proposed one. And approach your client. Between the time the warrant was issued in September of 2016 and it was entered into NCIC in May of 17, did you personally take any efforts to arrest Mr. Davis?
Can you ask that again?
Between the time the district attorney's office approved a criminal complaint and the time the case was entered into NCIC, did you personally go out and try to make an arrest?
I did not.
Is that something that you would normally do as a sexual assault detective?
I would say it's on a case-by-case basis, but it's very seldom that I would, only because I don't have the tools as a patrol officer would have, or these other teams that go out and locate these suspects. So I'd say it's very seldom that we do that, but I have done that in the past before.
But you did not do it in this case, right?
Not in this case, no.
Just to memorialize the entrance into NCIC, may I approach you with this?
Yeah.
Showing you it's been marked for purposes of identification as state's proposed Exhibit 1. Do you recognize that document?
Yes, I do.
And how is it that you recognize it?
It's an NCIC entry or a hit notification.
For Raymond Davis,
That's correct.
the individual you identified here in court today.
That's correct.
Fair and accurate copy of that NCIC information as it is submitted in this case,
That's correct.
with the admission of one.
Well, first of all, any objection from the defense?
My colleague tells me, or represents the officer of court, that that's the NCI record. We don't doubt her veracity. We will accept the representation.
Okay, so the only issue is just because the rules in regards to NCIC are so strict.
I was going to ask you to see one.
Yeah, I'm going to admit it, but we're gonna have to admit it under seal because it is an NCIC pursuant to the federal guidelines. So yeah, it'll be admitted. We can talk about it during the course of the hearing.
That NCIC entry indicates in-state only extradition, is that correct? Up top.
Yeah, it says in-state pickup only.
At that time, you did have a known address for Mr. Davis, is that correct?
Yes,
In doing research for this case, did you discover whether or not Mr. Ray Davis also had a California address to include a California driver's license back at that time?
I did.
Did you provide me with a copy of that?
Yes, I did.
I've provided a copy to defense counsel, if I may approach your board. Showing you what's been marked, the state's proposed exhibit 2. Do you recognize states 2?
I do.
And what is depicted in states 2 and how do you recognize it?
It's a California Department of Motor Vehicles driver's license for a Davis Raymond Tyrone.
That's the same that you delivered to me, is that correct?
That's correct.
And in the course of your duties, did you pull that from the California DMV?
I did.
State would move for the admission of 2.
Defense?
No objection.
Okay, it'll be admitted.
And the issuance date of that California driver's license?
It's California.
No, but what date was it issued?
Oh, I'm sorry. It was
Objection,
March.
hearsay. It's out of state records. The documents and that speaks for itself.
Yeah, well, I mean, if I can, he can either say it or I can look at it, so let's just let him say it, because either way, it's already in evidence, so can someone just tell me the date?
It's March 23rd of 2015.
Okay.
With a California address, correct?
That's correct.
Now, were you also able to pull body camera footage of the dates that Mr. Davis was actually arrested on?
I did.
Did you pull and review that footage at my request to kind of look into this issue?
I did.
And I'll have you look at them in just a little while, but generally, what was depicted in those body cams?
It was a traffic stop made by one of our patrol officers, and Mr. Davis was driving, I believe, a red Chevy vehicle, and the officer initiated the traffic stop, requested the driver's license, insurance card, and I believe the registration for the vehicle, and Mr. Davis produced his California driver's license.
Did he, in that body camera footage, indicate his state of residence on the arrest date?
Yes, he did.
What did he say?
I believe he, on 3 different occasions, I believe he mentioned,
Hearsay.
Statement of the defendant, Your Honor.
I believe on 3 occasions he stated that he resided in California.
And this was from April 19th of 2019?
That's correct.
I'll get you guys a copy of this. And what's your report? Mark has proposed to. Detective, you sent me links to that body camera footage, is that correct?
Yes,
And prior to today, you reviewed those, but you and I have not had an opportunity to look at this disc, is that fair to say?
that's correct.
I would ask the court's permission to play subject to connecting up.
Subject to what?
Just
Oh,
connecting
to lay
up.
the foundation,
Yes.
yeah, that's fine.
Is the officer, let me get a proffer from my colleague, is the officer whose body camera footage this is going to be here?
No.
I object.
Ms. Connell?
I don't believe that we're required to have the officer here. This is for a very limited purpose of this hearing. If we were talking about presenting it at a jury trial and having somebody narrate what was happening, what was transpiring, but this is just for the limited purpose showing the court that Mr. Davis indicated on multiple occasions he was living and residing in California, coupled with a California driver's license.
Okay, I'm gonna allow for the purposes of this hearing, so we can look at the totality of the circumstances under Doggett and Barker. Is your screen on in front of you?
Yes, Your Honor.
Just for the record, Detective, do you see two files indicated on the disc, 467 and 467-2?
Yes.
Are those consistent with the links that you sent me to download? If you know.
I don't
I don't know if
answer.
my investigator renamed them. Okay, well, let's just take a look at the beginning and see if you're right. I apologize, the date is April 20th of 2018. Do you see the beginning of that video?
Yes.
Does that appear to be consistent with the body cam footage that you directed myself and my investigator to?
Yes, it is.
Okay. Permission to continue playing, Your Honor?
Yeah, we're playing the first one entitled 467 first?
Yes, ma'am.
All right. Can you pause it, Ms. Collins? I'm having a hard time hearing the total of it. We ran into this situation once before, and we could play it through the TV. Do you remember how we did play it through the TV during that trial? You did turn up the TV? Let's see, how did we do this with the?
I mean, I can make copies and deposit them with the court.
I can just hear.
Turn it up either.
Yeah, I turned it over my head off.
Yeah.
So trying to play it again.
Will you try it again, Stacy, please?
The first 30 seconds, Your Honor.
Oh, yeah, no, I know body cam
Okay.
is always muted in the first 30.
Yeah, that first 30 seconds was my bad. Apologies.
No, it's always mute on body camera the first 30 seconds.
Well, I had it off.
Oh. Okay, did you hit play again? I always forget how we get it to create through the overhead. It's something to do on the DA computer. There's a button that you press, and now I'm trying to remember which one it is.
So I have the volume turned up all the way on here. It's at 97.
Can you just, if you wouldn't mind, if you would just stand next to me, because if I could just hear it from your computer. Yeah, or maybe try that. Ms. Collins, would you put the microphone?
Yeah, I'm gonna go back a little bit here. Let's try it then.
And then do you see that one microphone over there to your right? See that little blue ball? Go back to where you can see play. And you see that little blue ball right there? Hit that all the way up.
Okay, that
And
might
now
help.
let's try that. Now we're still under mute though, because it's 5 more seconds.
There we go. My bad.
Hey Raymond, what's your social? Where was the last place you lived? So it's here in California? What's the address in California?
That one?
The one in the ad?
It's on the ID.
Okay, where do you live here?
3055
3055.
South Nellis Boulevard. Apartment 2145.
2145. Okay, have you been arrested or cited before?
What?
Have you been arrested or cited before?
Only for tickets.
Okay, nothing else?
No.
When was your last ticket?
I just paid a big ticket.
Yeah, okay.
Like $800 something I paid the court. That was months ago.
Okay. Alright, just hang tight, okay?
Okay.
Kim, so is the stop for the warrant, or is the stop for just a traffic, was it you just said a traffic violation?
That was traffic violation.
Okay.
I don't have anything out of Premier One yet, Your Honor, I apologize.
No worries, I just wanna make sure, I didn't know if it was the warrant or what.
I believe, Your Honor, that video clip is not the initial contact with Raymond Davis in the vehicle. I think that's the second trip up to the vehicle.
Hey Raymond, what's your social? Where was the last place you lived? So it's here in California? What's the address in California?
That one?
The one in the address?
It's on the ID.
Okay, where do you live here?
3055
3055.
South Nellis Boulevard. Apartment 2145.
2145. Okay, have you been arrested or cited before?
What?
Have you been arrested or cited before?
Only for tickets.
Okay, nothing else?
No.
When was your last ticket?
I just paid a big ticket.
Yeah, okay.
Like $800 something I paid in court. That was months ago.
Okay. Alright, just hang tight, okay?
Okay.
Quick forward and second partner.
It's just lived in the same one. Oh geez, where'd it go? Your Honor, if I could commence 467 dash 2.
Okay.
Just for the record, I actually played them in reverse order. This is the initial contact.
Oh.
TV, can you copy my location to 4137 South Mill Parkway? Alright, go ahead and put your hands on the steering wheel for me. Without reaching for anything, do you have a registration or driver license without reaching for anything?
Yeah, without reaching.
Yeah. Alright, all you guys have IDs with you guys?
First of all, those are my kids. They're underage. Second of all, yes, I have a...
That wasn't what I did not ask that, okay. I just asked for ID, it's a yes or no question.
And why are we being stopped?
But the reason why I stopped is because when I ran your plates, a couple warrants popped up. Okay? So, slowly reach for driver license, registration, and insurance. Where are you coming from? Where?
The dispensary.
Okay. Where are you heading to?
Home.
Where do you live?
3803
Okay.
3055.
So why do you have a California driver license?
Because I lived in California.
Okay. Yeah, you know, it's a law that once you live here, you have to have 30 days to change it.
What?
You have to have 30 days to change
Yeah, but
it
I
after.
still live in California too.
Okay. Where's your registration at? Where's your registration at? Go ahead, reach for it.
I gotta unlock the key.
Go ahead. Any insurance paperwork is in here, sir?
I still got a residency in California. That's why.
Okay.
I think I got. You want the insurance?
Yes, please.
being there.
Alright.
Until I took
So when I come back, just go ahead and put your hands on the steering wheel, okay? Good for you. Talk to my partner.
And it's just the same video looping, Your Honor, same body cam. State would move for the admission of 3. I mean, I don't, did you already admit it, or did you just let me play it?
No, I admit it was me.
If I made deposit, it would be clerk.
Yes.
And I know, Detective, the video speaks for itself, but the defendant claimed in that video he still had residency in California as well.
Yes.
You're not- And that was as of April of 2019.
That's correct.
We passed the witness.
Defense.
Detective, do you have a chance to review your file in this case?
I have.
Did you in fact review your declaration of arrest?
I have.
All right, so are you, without, I know you do a number of cases, but you're generally familiar with the facts that you allege them in the warrant of arrest?
Yes.
The allegations here is that a couple of young women went over to Mr. Davis's apartment, correct?
Yes.
All right, in fact, his apartment was a key factor in the case, correct?
Yes.
All right, you personally went to the apartment to investigate, correct?
Yes.
You got a summons and an arrest warrant for activities that occurred in Mr. Davis's apartment, allegedly.
That's correct.
Then did you ever go to Mr. Davis's apartment ever again to serve the arrest warrant?
I did not.
You know, he still has a residence there and is actually a licensed voter there. Did you make any effort to find him at all?
Objection compound.
All right, I'll rephrase. Did you make any effort at all as a submitting detective to ever find him?
After the warrant was submitted, I did not.
All right. Now, how many cases have you submitted, detective?
I'm sorry, in total as an essay detective, like,
In total, since you've came out of patrol.
Well, I've been in the investigative side for about 10 years and the criminal investigative side for a little over 8 years, and I would say 2 to 5 cases a month could be the amount of cases that I could submit to the DA's office. So roughly speaking, maybe 50 to 60 cases a year that I
Okay.
could submit.
And that's over 15 to 18 to 20 years? 18 years?
In the investigative side for where I'm at, probably about 8 years that I've done that.
Okay, so you've done a large number of cases.
That's fair, you could say that.
All right, so I mean, I'm just, this isn't your first year and this isn't your first rodeo.
That's correct.
Now, sir, people's memory fades with time, does it not?
I can't speak for everyone else, but I could speak for myself. Sometimes it's difficult to recall something in the past.
All right, and a statement gotten from a witness recently after events is significantly more reliable than one taken a few years after the fact, correct?
Objection, argumentative.
I mean, you're a detective, I just want to make sure I understand.
I think every case is different, sir.
All right, would you agree or disagree with the general proposition that the passage of time makes solving cases harder?
I can't say neither here nor there with that question, because most of my cases are allegations in the past and some of them are allegations in the present, so.
Sir, did you collect any physical evidence in Mr. Davis's apartment?
I did not.
All right, did you impound any DNA samples?
Objection beyond the scope of this hearing.
I'm going to do a very clear point now, just a couple more questions, Judge.
come to it soon, because I feel like this is outside.
Sir, there's absolutely no physical evidence in this case at all, just memory.
Same
Okay,
objection.
so that's gonna be sustained.
All right,
This is
sir.
about his arrest.
Did anybody on your squad make any effort to arrest Mr. Davis?
No.
And the allegations date back to what year?
July of 2015.
If I were to show you your declaration of arrest, did you actually make reference to events that occurred back in 2014? Would that refresh your recollection?
Yes, sir.
Okay, so 2014.
Can you ask that question again?
Sir, yeah, approach.
Yep.
And, Jay, you want to pull the last 2 pages out of this? I've got 3 or 5 of them. Keep it all together at once.
I don't have any objection to admitting his report in its entirety. As long as you clarify the record, Mr. Miller, it was 2014 and 2015, not just 2014.
Does it have the minor change and stuff on it?
Yes.
Let's make it a court's exhibits are never, public, right, Keith? All right, so let's make that a court's exhibit, Mr. Mueller, if you're moving it in, just because I don't want minors' personal information.
That's fine, Judge, but I'm also going to need that back for hearing.
Yeah.
This is court's exhibit.
Court's exhibit, please.
Court's exhibit, 1 0.
No? From your score back.
No objection.
First showing what's been marked as Court's Exhibit 1. Showing you paragraph 3 on page 2. What is the date of the allegation there?
2014, sir.
2014, put 2 final point on it, this is 7 years later, correct?
Ask that question again.
I'm sorry, 2014, we are 5 years later, correct?
That's correct.
All right, now, what date did you submit this case?
September of 2016.
All right. And to the best of your knowledge, has anybody, your unit, any squad, made any effort to find Mr. Davis?
I can't speak for another squad, sir.
Anybody in the Las Vegas Metropolitan Police Department make any effort to find Mr. Davis?
Objection, speculation.
Sustained.
If you're aware of anybody trying to find Mr. Davis.
Again, sir, I can only speak for myself, and just to kind of go back, normal practice for me is to communicate with detectives and other details to apprehend subjects that are involved in my investigations, and in this case, I cannot recall if I did or I didn't, but normal practice for me is to communicate with another detective to apprehend someone. So to answer that question, I don't know in this case
The answer
if
is
there
no.
was an effort to apprehend Mr. Davis.
The answer is no, you're not aware of any.
I don't recall, sir.
Oh, I need a point of clarification. When you say it's normal practice for you to generally reach out and speak to someone, can you give me an idea of who you're talking about? Would that be CAT? Would that be patrol? Like, who do you normally reach out to?
It could be various details, Your Honor. It could be a patrol officer on the street or that sector beat. It could be the criminal apprehension team as well. It could be a repeated offender team as well. So it's most of the time I would say I would case note it in a investigation to say that I spoke with the detective that's assisted me to find this person, and at times it's I'm out of the office and I don't case note it or I forget to case note it, but it's normal practice for me to try to communicate with other details to apprehend subjects that I'm looking for.
Sir, when did you go to Mr. Davis' apartment? Month and year would be fine, or even season and year.
I think without looking at my records, I believe it was December of 2015. I believe, I'm not sure, sir.
When did you ask for a warrant?
September of 2016.
And in the intervening 3 years, did you go by the apartment at all?
I did not, sir.
And this is a case where you actually knew exactly where he lived.
I had documentation from I think his California driver's license to show he also probably lived elsewhere, but I wasn't 100% sure.
You just saw the video where he actually gave a Nevada residence as well, correct?
I saw that video, yes, in the stop in April of 2019.
Do you remember what that address was when he gave?
I believe it was 3055 South Nellis, apartment 1245, if I'm not mistaken.
May I approach?
Yeah. Where's
Sure.
the arrest warrant? Do you still have it?
No, you have
Okay. Can I see it, please?
the declaration of arrest exhibit.
Yeah.
That's right. Sir, the address that Mr. Davis gave, is it the same address that's on this jury summons?
Yes.
So Clark County actually had an address form for jury summons, that's the same address he just gave you in the videotape, correct?
He did not give to me, sir. He gave it to the patrol officer that made the stop.
Okay, but it's the exact same address.
Yes.
Don't believe I have anything further.
Okay, Ms. Collins?
So, part of the reason we're here is so that, like, defendants don't have unfair surprise about these, like, looming criminal charges. You know what I mean? So they're just not out there, they don't know anything. Other than going to his apartment prior to requesting our office to approve a warrant, did you have a conversation with Mr. Davis?
I did.
And when did that conversation take place?
I believe it's on or around December of 2015.
Was that by phone or in person?
That would have been on the phone, if I recall correctly.
You called him?
I did. I left I left a business card at his apartment, so I believe he called me.
Did the person on the other end of the phone identify himself as Rick Davis?
Yes, he did.
Okay, did you have a conversation?
Yes, we did.
And what did you tell him? What
Objection
did he
beyond
tell
scope
you?
of cross, we didn't talk about a phone conversation.
I would agree with that, but for purposes of this hearing, obviously you need to understand the totality of the circumstances. So Ms. Collins, go ahead, overruled.
Did you tell him your purpose for trying to get in touch with him?
I did.
What did you tell him?
I informed him that I was investigating the case involving a Vanessa Robinson and a juvenile, and he stated he did not know a Vanessa and did not want to speak to me about the investigation.
But he told you he did not know of Vanessa Robinson.
That's correct.
Did you let him know the investigation was ongoing?
Yes, I did.
Nothing.
When you said you left the card, where did you leave the card at?
It's usually lodged between, when I leave cards, Your Honor, I leave them lodged between the door and the frame of the door.
No,
Oh.
I'm sorry. It was a poor question. Are you talking about 3055 though?
Yes.
Okay. Ms. Collins, is that it?
That's it, Your Honor.
All right, defense?
One minute for its indulgence.
Yeah, go for it.
While they're conversing, Your Honor, just for purposes of the record,
Yeah.
I would ask that the court take judicial notice of the information on file that includes the charges through 2015, not just 2014. Does the court have a copy of the charging document?
I would have it on Odyssey, but
Yeah,
are you
but-
just stating that there's charges from 14 and through 15? Is that what you're saying?
Yes.
Okay. Yeah, that's fine.
Would you like a copy?
Yeah, please.
I don't know why this has to be.
All right.
Ms. Martinez, or Detective Martinez, do you have the date that you actually spoke with Mr. Davis?
I have it documented in my investigation, I just don't know it off the top of my head, no.
All right, so the passage of time has worked against your memory.
Objection, argument.
Sustained.
Nothing further.
Ms. Collins?
Your Honor, the state doesn't have any more witnesses. I have no more questions for Detective Martinez, unless the court has any specific inquiry.
Yeah, just one. So when you say it's generally, not something that you do is arrest individuals, right? So you're stating that you either basically submit the arrest warrant or you contact somebody to do it, whether it be patrol, CATS, this or that, right?
In some cases, yes, Your Honor.
So I guess what I need to know for the record is why is that?
We get about, any detective in our unit gets about 80 to 120 cases a year, depending on the amount of cases that are assigned and the amount of cases that are, or detectives that are working. So once the case gets submitted through, we pretty much close the case out and it's out of our queue. So we don't have it as an active investigation. It's a closed investigation on our, it's on a case-by-case basis depending on, you know, the amount of cases the detective or I have, and the amount of work that I'm doing with the other cases or the priority for this, for the detail of the cases that we're investigating as a team as well.
Any follow-up based on that?
Yes. You do on occasion probable cause arrest,
I do.
and in a circumstance such as this where you have a delayed disclosure and no further victim perpetrator contact, does that influence whether you submit for a warrant or probable cause arrest on occasion?
It does.
Why is that?
Sometimes there's outstanding witnesses of the case that need to be interviewed, so an arrest may not be imminent for the detective. Sometimes there's people we want to contact to locate the victim because the victim has moved, so it could delay the investigative process for the detective, but that would be an example of why a case would be submitted to a DA's office, but not always.
Would it be fair to say that there was no imminent threat or continuing threat to that victim as well?
That's correct.
Mr. Mueller?
Sir, the address that you said you went over to Mr. Davis' address as part of your investigation.
I'm sorry, say that again, sir?
Previously, I'd asked you whether you'd been to Mr. Davis' address as part of your investigation. Remember that, sir?
Yes.
Do you remember that address?
It's 3055 South Nellis Boulevard?
And is that in fact the same address that he gave 6 years later in the videotape?
That's correct.
And that's the same address that's actually on this jury summons?
That's correct.
Sir, have you ever run Mr. Davis's name on the internet just to see what comes up?
I believe so. I believe I have.
Okay. And did you have any trouble finding him on the internet?
I did not in this case, no, I didn't.
Did not have any trouble?
No, I did not have any trouble.
Okay.
In fact, he owns a local retail store, correct?
I don't know, sir.
Right. So finding him was simple as actually Googling his name?
Well, in this case, I found him through Facebook.
Okay. I have nothing further from this witness.
Sorry, so just so you guys know, obviously in trial, I don't ask all my own questions, but for purposes of a hearing like this, I obviously need to understand everything. So what I do need to understand is between the time you spoke to Mr. Davis and submitted the arrest warrant to the district attorney's office, what other investigations were done? And if you, obviously, you need a copy of this, I took it away from whoever, but I need the record to reflect if you did anything.
Okay, so from the time I spoke to Mr. Davis, Your Honor, to the time I submitted?
Yeah, so early 2016, you speak to the defendant, and then you submit it in early fall to to the DA's office. So what was done? And because you just said sometimes there's other things you need to do.
That's correct.
What was done here?
Okay, so in this case, I believe I had conducted a photo lineup with Vanessa Robinson, which was done, I believe, requested January, February of 2016, and it was received February of 2016. I did have to attempt to locate the witnesses mentioned by Vanessa, the victim. One witness in particular, can I say her name?
Yeah, of course.
Adriana, I believe her name is.
Okay.
And I finally located her and conducted an interview to a witness of one of the sexual acts she described in Mr. Davis's apartment. And that interview was completed August of 2016. And that was a key piece or key witness to one of my allegations. And there was another juvenile outstanding by the name of China Rolls. I had her name misspelled, and I think that was the obstacle in my investigation to locate Miss Rolls. And I couldn't locate her to conduct that interview. So I also completed a photo lineup with, going back to Adrina, a photo lineup with Adrina for this investigation as well.
Okay, and then after those things, you submitted it?
That's correct.
Okay, got it.
May I follow up, Your Honor?
Yeah.
Detective, in preparation to go to trial in this case, you and I sat down and did a chronology of your investigative work, is that correct?
Yes.
Do you recall in preparing that chronology, your phone contact with the defendant was January 12th of 2016? Is that something?
Sounds about right.
And at the time the photo lineup was shown to Vanessa Robinson, she was housed in Caliente.
Yes.
So that photo, you didn't personally show her that had to go through the mail and then be returned to you, correct?
That's correct.
And do you think it was returned to you around,
Objection leading.
well,
Just if you could just ask it in a different way, when was it?
do you know when it was returned to you?
February of 2016.
And did you also get a search warrant for Facebook?
Yes, I did.
When did you do that?
I believe I received the actual approval for the warrant April of 2016, and I may have preserved it well before that. I don't have the exact date, but usually we have to wait until Facebook gives us the okay to upload a warrant for a profile, so it takes a little bit of time to communicate with the company.
And the date that you finally contacted and interviewed Adrian Walker, do you remember that date?
That was in August of 2016, I believe.
And showed her a photo lineup the same date?
I did.
Nothing further, I just want to put the times on the record.
Yeah, thank you.
Nothing further.
All right, sounds good. Thank you for your testimony. You're excused.
Thank you, Your Honor.
Ms. Collins, any other witnesses?
Your Honor, the state does not have any other witnesses tonight.
Mr. Mueller, did you wish to present any witnesses for purposes of this hearing?
Yes, Judge, with the strict if the court with strict admonition that Mr. Davis is going to testify just to his whereabouts and his location for the last several years, we would like to call.
Of course, sure. Mr. Davis, go ahead and step up to the witness stand, please.
Yes, ma'am.
Please remain standing, raise your right hand. You solemnly swear the testimony you're about to give this action be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You may be seated.
Please state your complete name, spelling both your first and last name for the record.
Raymond Davis, Raymond, Davis, Davis.
Thank you.
Mr. Davis, do you have an apartment here in Las Vegas?
Yes,
Las
sir.
Vegas Valley?
Yes, sir.
And where is the address of that apartment in Las Vegas Valley?
3055 South Nellis Boulevard, apartment 2145.
All right, and what year did you first lease 2145 on South Nellis?
3055?
Unit number 2145.
Oh, got you, sorry. Okay.
Pretty sure it was 2000 and maybe late 2009, early 2010.
All right, and have you resided or continued to pay the rent at this apartment since then?
Yes, I'm the only one that pays rent.
All right, so you've been paying the rent on this place now for going on 9 years?
Not over 9 years. This is going to be my 10th year
All right,
in that
well,
apartment.
All right, and what line of work are you in, sir, currently?
I'm a world-class poker player.
All right, and you have another enterprise besides poker?
I have a retail store on the Strip called Real Grinders. It's 3863 Valley View Boulevard.
And
Suite number
do you
4.
advertise for your business?
Daily.
All right, and if someone was to look for your store at Real Grinders, is it come up on the first try on a Google search?
Objection, speculation.
If you Google search
Just 1 second, if you know, first of all, have you ever Google searched yourself?
yes,
Okay, so if you Google searched yourself, you could tell me what comes up.
right.
Go for it.
If you Google search Raymond Davis, it's over 50 pages. My store comes up.
And your winnings in the poker
My
tournaments?
winnings, my place, my Facebook page, basically everything about me. My whole life comes up right on Google.
Sir, do you occasionally go to California?
Yes, I frequent California pretty often because I host poker tournaments at big casinos like Commerce, Hollywood Park. They pay me to come down there and put on a presentation at Hollywood Park, Commerce, not bicycle, but numerous, because almost every casino wants me to come down there, so.
All right, and so are you frequently out of town for extended periods of time?
Yes, sometime I'm gone 2 weeks. Sometime I've been gone. I've been known to be out of town for a month and a half. I've been gone for 3 months. Just depends. I have a friend, and
Just real quick, do you occasionally sublease out your apartment?
I have people that stay at my apartment, but they don't pay rent.
All right, but there are occasionally people other than you staying at your apartment with your permission?
It's always people there at my apartment.
Okay.
Even families.
All right, so do you keep a diary or journal of the comings and goings of people in the apartment who is staying there during what time?
No.
So do you have any way of retrieving that data other than your memory?
Yeah, other than my memory, I can't tell you who was there at a certain amount of time.
All right. And do you occasionally stay down in Southern California for extended periods of time?
Yes.
Did there come a time when a good friend and fellow poker player lost his wife and you spent several months down in California?
Yes. The residence on my license is my friend's residence. I have a room in his house. His name is Fred, and his wife passed away, and I was like really close to her. And when she passed away, I stayed there for 4 or 5 months while she fought cancer, and I stayed there. I went to some tournaments with Fred, and Fred almost died. He's 86 years old.
So despite the fact that the apartment was in your name for 9 years, you've been out of town for up to 3 or 4 months at a time?
Yes, sir.
Okay, personal business and business.
Yes.
All right. Do you keep a business log of your comings and goings down to California?
No, I don't, but it's on the internet. All my tournaments if you Google the casino, it will tell you a Real Grinders tournament hosted by Raymond Davis, which is me. They pay me upwards of $3,000, $4,000, $5,000 to stay there. And
Showing you what's been marked as defense A for identification. Did you get a jury summons to appear in the Clark County District Court?
yes, I did.
And is this document that jury summons?
Yes.
All right, and is that the address that you've lived at for the last 9 years?
Yes, it is.
Move to admit defense A.
That's fine, please take a look at it once again.
Sure.
Before you put that case. Yeah, I will. Changed.
Ms. Collins, was there any objection?
No, Your Honor, I apologize, no objection.
All right, so it will be admitted.
Sir, did you have a friend by the name of Gavin Smith?
Yes, I did.
All right, and who got arrested? So was Mr. Smith.
I would play the World Series of Poker, and when you play, sometimes you get backers. And that means people put up the money for you to play. Gavin would frequently put up the money for me to play, and when he put me up, they make us play 12, 13 hours a day.
Mm-hmm.
So I would basically stay with Gavin at the Rio while I play poker for 12, 14, 15 hours a day. Sometimes 16 hours you have to play.
All right, and during the passage of time from the time you moved in till now, did you have extensive contact with Mr. Smith?
He was one of my best friends.
All right, he would have known when you were comings and goings and would have been...
Yes, I talked to, it wasn't a day I didn't almost talk to Gavin.
And Mr. Smith is now passed.
He died of cancer.
All right, and Mr. David Arrington.
David Arrington was another friend of mine for over 20 years, and I would go to California and stay with his family. Fred was located in Chatsworth. David Arrington was located in Los Angeles, and sometime I couldn't make the drive because Chatsworth, the drive was an hour and a half to get to Fred's house, but I had to get up the next morning to go host another tournament or be somewhere at a tournament. So I would stay at David Arrington's house with his family.
All right, and Mr. Arrington would have known and been able to have some record of when you would come and gone?
Yes.
And he's now dead as well?
Yes.
And to the best of your recollection, when did Mr. Arrington die?
He died in about, I think, February, I think pretty sure he died in 2015, and it would be like in February.
All right, and how about Mr. Smith? When did he pass?
Mr. Smith just passed away in January.
All right, and he would have been able to have some knowledge of your comings and goings?
Yes, he knew where I was all the time. When they sponsor you, it's like you're working for them, and you have to check in. You can't stay out late unless you're playing poker. It's
almost like they give you a lot of money. They want to keep tabs on you.
right. They give you $20,000, $30,000 or whatever in your pocket. They don't want you out partying or not. Although I don't party or nothing, but they don't want you out. And the reason why you stay with them is because you got a large sum of money, and every day you're playing a tournament that costs $3,000, $4,000, $5,000, and you're playing live. So you don't want to leave the casino with that kind of money, especially if you're known like me or him or whatever. So we would just stay in the casino. I mean,
so both of these men would have been able to substantiate where you were and where you weren't.
Yes.
And they're both dead.
Yes.
Let's try to get it out.
Nothing further.
Ms. Collins?
So, Mr. Arrington died in 2015. Is that what you said?
Yes.
Okay, so that would be prior to the warrant coming out in this case, right? Prior to the warrant for your arrest?
Yes. I don't know when it was a warrant for my arrest.
So from 2009 or 10, when you moved in that apartment, to now 2019, you routinely take trips to California.
Yes.
And sometimes you stay for days, sometimes you said, I think, up to 3 months, is that correct?
Yes.
So you got a driver's license down there,
Yes.
told the officer in the video that we watched that you had a dual residence, California and Nevada, correct?
Yes.
And is that accurate information?
Yes, at the time I was staying in both places.
So in April 2019, you were staying in both states?
No.
That's what you
Fred sold his house and moved to Vegas.
in
So when I go to California now, I stay in hotels.
we're not talking about now.
Okay.
We're talking about prior to your arrest. In 2019, did you take trips to California prior to your arrest?
In 2019, I have not been in California.
Between January and April of 2019, you were not in California.
January of 2019,
So this year.
This year that we're in.
I'm thinking,
It's all on the internet, right?
yeah, I mean, I'm trying to think if I hosted a tournament, but 2019. And 2019 was in California.
Did you play poker tournaments in California between January and April?
Yes, I do. But I play so many tournaments, I wouldn't know the exact day of when I played the tournament.
But it's fair to say that over the course of the last 10 years, since you've had a lease on that Nellis apartment, you've spent anywhere from days to a month to 3 months in California and back and forth between here and out.
Yes, it's very seldom I would spend 3 months. The only time I spent 3 months is when Fred's wife was dying of cancer and he needed help. That's the only time I recall I ever spent 3 months in California since I lived there.
Okay, well, and I heard you say 3 months on direct, so I'm just trying to clarify.
Right,
okay?
yeah.
And you said on direct you're frequently out of town at least 2 weeks at a time.
Yes, sometime 2 weeks at a time.
And why did you find it necessary to get a California license?
Why did I find it necessary to get a California license?
Yes.
I always had a California license. I had a California license for over 20 years.
Have you seen the one that I shared with Mr. Mueller today?
That's called a renewal. They make you renew on your birthday.
And you renewed that in 2015?
Yeah, at a certain amount of time, California makes you renew your driver's license. So I had to go, I was there to renew my driver's license. I have never had a Nevada, I have always had a California driver's license because I had it. You know, I mean, I had it already. Why would I get another driver's license?
Well, you told the officer you had both driving licenses.
Yeah, I stay in both places.
That's all, nothing else.
So what's this, I guess what I'm confused at is, so there's a difference between, going there and always traveling for the poker and then having a residence. So the residence, is that Fred's residence when he
Yes,
had a driver's license?
Yes, and that's his address on the residence, the Chatsworth.
And then, sorry, Fred has passed away as well?
No, Fred is still here. He's gonna come here.
Fred is still here, it's the other
He's
Fred.
86. Gavin Smith
That passed away. So the residence on the driver's license is Fred's.
was Fred. He sold the house. Yeah.
And then when did you get the driver's license for Fred's, putting Fred's address as the residence?
I had a driver's license, right, and then when I renewed it, when I renewed the driver's license, I put his address on there, Fred's address, because I didn't have any address really in California anymore.
But when was that?
When I moved out of California, I moved out of California in 2009.
So when you go to renew it, and you put Fred's residence,
Right.
when was that?
I'm pretty sure, I think it was 2015, the last time I renewed it. 2015, 2016, on my birthday, March 24th.
It's on the license,
Oh, it is, okay, and it says that?
it's 2015.
Okay,
Yeah, so I knew it was 2015 or 2016, I renewed my license.
got it. Okay, Mr. Mueller, anything else?
No, Your Honor.
All right, you can return to your seat, thank you. Anything else as regards to presentation of witnesses?
No, Your Honor. Defense has no additional witnesses for the purposes of this hearing.
Okay. Okay, so now we're just going to argue. Mr. Mueller, which one of you is going to be doing the arguing?
And my learned colleague will handle it, Your Honor.
Okay. So I type out all the notes, so when you're talking, if you see me typing, I'm just typing what you're saying, so I can go through it in a moment when I'm making my ruling. But before we do that, let me start off with where my mind is, so you know where I'm going, okay? So, first I just want to make sure I understand from, like, the timing of everything. The complaint alleges the actions happened between, in 14 and 15. Are we all on the same page? Am I right about that? All right. So then I looked at the declaration of warrant summons, and as the court looks at this, I don't have any issues in regards to how long the investigation took place from when it happened to the disclosures to the follow-up investigation to the arrest warrant. So I want to make clear about that. Like, I don't see anything wrong with that. I think that the detective discussed why the timing, and I think that that was appropriate. Where the argument should be is from when the arrest warrant gets put into the system in September of 16 to the date of arrest. I have it in my notes. What is it?
April 20th of 19, I'm sorry.
That's okay. So, yeah, so September of 16 to April of 19, right?
Yes.
Okay.
Yes, that is correct. Yeah.
So when we're arguing about the things, I think that that time period is critical. I don't find any of the time period from when he was being actively investigated to the time the warrant was input to be critical to this analysis. So go ahead.
Okay, yeah, and that is absolutely correct, Your Honor. So first of all, there's only 4 elements to the Doggett evaluation, to the Barker evaluation. That's length of delay, reason for the delay, whether or not the defendant asserted their right to a speedy trial, and prejudice to the defendant. Let me jump around here a little bit because some of these are easier to knock out than others.
Okay.
Defendant's assertion of the right, I think we're all pretty well in agreement that the defendant has steadfastly asserted the right to a speedy trial. So that one seems to be pretty well agreed on, even in the state's opposition.
Do you agree with that, Ms. Collins?
I agree that he has asserted it, yes.
Okay, so we can agree on that.
So that element we can leave aside. That is settled. Length of delay and prejudice work together. So I'll actually leave those for a more robust discussion together because they kind of blend together when you get to a certain point. Let's discuss reason for the delay. If the reason for the delay is on behalf of the state, if it is either negligence or bad faith, then that argues against the state and for the granting of the Doggett motion.
Well, I mean, there's a balancing test that has to be done, right? It's not automatic.
No,
so
absolutely
if it's in bad faith, it completely weighs in your favor.
Absolutely.
If it's found to be negligence, it's not that it's excused, but there's more of a balancing test that needs to be done.
I believe the way Doggett and its progeny discuss it is that if there were bad faith, it would be nearly a fait accompli. And if it's merely negligence, that weighs in favor of granting the Doggett motion, but not as strongly as bad faith.
I don't know if the language is as strong as, let's make sure we're all on the same page, because I'm not sure that that language is that strong. It can be found in Barker too.
Well, I think we can solidly say that in Doggett they found that it was negligence and they granted the motion to dismiss. The same was true in Barker. They found that it was negligence and they found that weighed in favor. Nunzio, I believe that's the right. Oh, sorry, Inunza.
Well, that's Judge Ellsworth's opinion, though.
Yeah.
So what Doggett says is, Barker made it clear that different weights are to be assigned to different reasons for delay. Although negligence is obviously to be weighed more lightly than a deliberate intent to harm the accused offense, it still falls on the wrong side of the divide between acceptable and unacceptable reasons for delaying a criminal prosecution once it has begun. And such is the nature of the prejudice presumed that the weight we assign to official negligence compounds over time as the presumption of evidentiary prejudice grows. So I don't think it's as clear as you're making it. I just think it's saying the court needs to do a balance test.
Sure.
So go from that.
And it does seem to say that negligence falls on the wrong side
Yes.
of the acceptable, unacceptable.
Agreed.
That negligence is an unacceptable reason
Agreed.
for a delay. And here we have negligence just transparently in comparison to the other cases. It did come up, so let me cite US v. Vasquez that said it stands for, at least in part, stands for the fact that limited resources on the part of the state does not excuse a lack of zealous enforcement of the law and zealous pursuit of someone with an arrest warrant standing out for them. And then, in addition to that, we have, and here we have the officer saying on the stand blatantly that he got the arrest warrant issued, and then he didn't do anything to pursue Mr. Davis. The other officer who was on the stand couldn't point to any activity at all whatsoever because he didn't do any himself, and he didn't know of anyone who did any activities to bring in Mr. Davis. Mr. Davis was available. He could have been found the vast majority of the time, with a few, possible week-long trips, couple-day trips, 2-week trips to California for a poker's tournament here or there. Mr. Davis has been living in the Las Vegas Valley for 10 years. The distance between the police headquarters and Mr. Davis's residence, his residence that the officer knew he could be contacted at because the officer contacted him at before the arrest warrant was issued, before the charges were filed. The distance can only be maybe 2.5 miles, somewhere in that vicinity. All they had to do was drive down the road to pick up Mr. Davis. The one time they attempted to contact him at that address, it was successful, and then they just proceeded not to do so again for the next at least 2.5 years between the point where the arrest warrant was issued, the charges were filed, and Mr. Davis was actually arrested. This is negligence according to every other standard that Doggett and his progeny have established. In Doggett itself, the officer established the warrant, put it in NCIC, put it in scope at the time, I'm not sure exactly what program, but analogous to NCIC, if not the exact same, and alerted all of the exit ports for whether or not he would come back in, and when that failed, when that alert fell dormant, he didn't renew it, and that was negligence on its own. In addition, in Zunza and in Doggett, the defendant was in another state. So the state has made a major point of the fact that Mr. Davis has a California driver's license. He has a Nevada permanent address, a Nevada address that he's at the vast majority of the time. His home is here in Las Vegas, but he has a California address, and even if that was the case, when a defendant is in another state, officers still have an obligation, in order to not be found negligent, to track down people, to track down suspects with arrest warrants out in their name, even if they're in other states. And that wasn't even the case here. The only remote aspect of that is that he had a California driver's license. He was still here. He was still at his address the vast majority of the time.
So I have a question for you. When you quoted Vasquez, I feel like that's a little bit in contradiction to Barker, because in Barker it says a more neutral reason such as negligence or overcrowded courts should be weighed less heavily, but nevertheless should be considered, since the ultimate responsibility for such circumstances must rest with the government.
Oh, make no mistake, Your Honor. I didn't mean to mislead in any kind of way. Absolutely, the negligence or the lack of resources would weigh less than bad faith. But we don't need to get to bad faith. Bad faith, as they established, would be nearly definitive. There's a possibility the other factors could bring it back in favor of not granting the motion But bad faith, if we showed bad faith, that would be,
But when you just quoted Vasquez, you said that Vasquez said that shouldn't,
the lack of
lack of
resources.
resources shouldn't be considered, but.
No, the
Barker,
lack of
you're-
resources doesn't preclude negligence. I apologize for speaking over you.
No, that's okay. Well, I agree with what you're saying now, I don't 100% think that's what you said originally.
If I.
So I guess here's the thing, I mean, obviously you have a cop who said, I had his address, we didn't go look for him, okay? So I understand the argument for negligence. But I think really where the crutch of, where this case stands is the length of delay and the prejudice.
Okay,
Because-
fantastic. Let's get on to that. If we're ready?
All right?
First of all, I would point out that U.S. versus Salgado Ramiro establishes that when a delay is caused by negligence, a show of actual prejudice needs to be done when the delay is under 20 months. Here, we're 1.5 times that.
Wait, did you quote Salgado Ramirez in your brief?
Salgado Ramiro.
You can't come in here and give me all new cases, because how am I gonna have the ability, was that in your original brief?
I don't believe that was in our original brief.
And is it a United States Supreme Court, what is it?
It is Ninth Circuit, so it's 718 FED APPX 518. And that particular quote is at 520, Ninth Circuit, 2017.
Okay, go ahead.
And the reason why I needed to supplement that, Your Honor, was because more than 2.5 times the threshold for presumptive prejudice established in Doggett seemed more than sufficient to me, but to clarify, Salgado clarifies that a little bit further and establishes the bar a little more clearly.
Okay.
Furthermore, whereas here we have presumptive prejudice, we are well beyond that threshold, whichever threshold you're talking about. But we haven't just relied on presumptive prejudice. We've shown actual prejudice.
How?
As Mr. Davis stated on the stand, his two friends, one moment to get their names.
I know the name, I know what you're talking about.
Mr.
Yeah.
Arrington and Mr. Both of them have died. So at the very least, we have two witnesses who could have vouched for his whereabouts sometime in here, and could have vouched for the company that he kept throughout these periods of time.
Wait a second. So you're saying, I didn't hear any evidence that Arrington and Gavin, or whoever it was, could have discussed the facts of this case. I heard that they could have discussed where he was during this period.
They could have.
But I didn't hear any evidence from Mr. Davis that they could talk about whether or not he was ever with these girls or any of that.
And Your Honor, if we can establish sufficiently enough that enough people knew his whereabouts at various points in time, if we got the defendant on the stand, or if we got the alleged victim on the stand, and we could get to any kind of certain date, which is also uncertain given the amount of time, there's another element of prejudice. But if we could get to any kind of certain dates, or even a period, if he was elsewhere, if these gentlemen knew that he was elsewhere, they could have testified on his behalf. Furthermore, if the state is suggesting that he is keeping company with, underage girls, they could at least say that they'd never seen anything of that like, and that they had been around him extensively. They could be further witnesses to the fact that this was not the kind of thing they had ever witnessed. And that would at least establish more time when he could not have been with the alleged victim or the allegedly corroborating witness.
Okay.
And in addition, you have all the presumptive prejudices of time and memory fading and inability to,
Okay, but let's get specific with that, because that's what they're asking. We can't just presume it, right?
we can, and we should.
Why?
And because of both Doggett and Salgado Ramiro, which both established that presumptive prejudice means that it is presumptive. You need to show more actual prejudice the closer you get to that year line.
Actually, the footnote that you stated in Doggett, which is footnote number 1, says depending on the nature of the charges, the lower courts have generally found post-accusation delay presumptively prejudicial, at least as it approaches 1 year. We note that, as the term is used in the threshold context, presumptive prejudice does not necessarily indicate a statistical probability of prejudice. It simply marks the point at which courts deem the delay unreasonable enough to trigger the Barker inquiry. So I actually find that a little different than what you're saying, because I read it, and so then I read the footnote, and to me what this footnote is saying, and tell me if you disagree, it's saying, we find that as it approaches this year, then you need to start getting into these 4 factors and weighing these 4 factors. The way I have you interpreting it in the motion is that it's just automatic prejudice if you meet the year mark. And to me, that footnote doesn't, is that what you're saying that footnote means?
No, definitely the year mark is what triggers the
Analysis.
The analysis.
It doesn't say it's
as you go further into that year, Doggett also clarifies that impairment of one's defense is the most difficult form of speedy trial prejudice to prove because time's erosion of exculpatory evidence and testimony can rarely be shown, which is why they established there that in that it cannot be shown, there is a degree of presumption that it is there, and the further you go into beyond that year mark, presumptive prejudice and the need to trigger the analysis grows as you approach 1 year.
Yeah, but when are you telling me it turns into actual prejudice and you don't have to prove it?
Well, at some point in time, it definitely does. Salgado-Ramiro establishes that actual prejudice needs to be shown less than 20 months, but here we're 2.5 times that. We're 2.5 times the Doggett analysis. We're 1.5 times the Salgado-Ramiro. Here we're into the area that Doggett is talking about where it's been so long that receipts from poker tournaments and
But isn't that all on the internet for what your client said?
Physical receipts for poker tournaments, which could establish that he was actually physically there as opposed to a schedule, as opposed to an itinerary, which we plan on introducing as well, which would definitely be evidence in that vein, but additional physical evidence, video records of, any kind of video records, any kind of surveillance camera footage from the area where he allegedly met the victim. No, allegedly they met initially at
where they met?
Fatburger, was it?
I don't know.
They allegedly met somewhere in public. Any of the video evidence that could exonerate with a lack of her presence or his presence on that time, on those days, has long since been lost. We're well into the presumptively prejudicial here because of the amount of time. You heard how even the officer, in the state's motion, in the state's opposition, they say that this is not the kind of time that someone would assume they wouldn't be pursued for these kinds of crimes. First of all, I think it's telling that the state's argument necessarily presumes guilt. Secondly, even if you know that you are being pursued for these kinds of crimes, you can't help that your memory will fade. As a matter of fact, the officer, who certainly knew that this case was afoot, couldn't remember many things on the stand. Couldn't remember the day that he interviewed the alleged victim. Couldn't remember the day that he spoke to Mr. Davis, or the day, I think it was the same day, that he put his business card on Mr. Davis's door. Both of which were, by the way, to clarify, both of which were prior to when the Doggett analysis would start. Because they were both prior to the arrest warrant and the charges being filed. So we're well into the area where prejudice, although we have shown actual prejudice, we've shown loss of witnesses. In addition, the presumptive prejudice is more than accumulating here, just because of the necessity of the time, and we've not only is that common sense, but also we've seen it here on display on the witness stand, even from the officers, let alone from Mr. Davis, who wasn't responsible for pursuing his own investigation and his own arrest.
Okay, so, like I said before, I think I have a few questions for you. Don't worry, I have questions for Ms. Collins too, so I don't want you to think I'm just picking on you. Talk to me about the arguments obviously going to be made, hey, he knew about this investigation, he knew what was going on. That can be a little bit different than someone who has no clue, right? So how does that factor in your analysis of the factors?
Your Honor, if we look at this logically and we look at this literally, what Mr. Davis knew is that an officer called him about an investigation. An investigation is not the same thing as charges filed. An investigation is not the same thing as an arrest warrant. As a matter of fact, I think a reasonable person, and a reasonable innocent person especially, would receive a call from a police officer who's saying that there's an investigation ongoing, and when they didn't hear anything back in a month, 2 months, 6 months, especially when they knew that the officer knew where they lived and knew how to contact them within a day, almost immediately, even beyond the fact that he could have contacted, the officers could have contacted him online. A reasonable person would see that delay, and God forbid we get up to 2.5 years. If you even remembered it, that would be, you would have long since assumed that that case was gone, because otherwise they would have done something about it by now, certainly. And it would have happened, that presumption, I think, in a reasonable person would have happened well before 2.5 years. As a matter of fact, I think the initial timelines were much more reasonable. I think a reasonable person would assume that the police were not in pursuit if they didn't hear anything in a month, 2 months, 6 months.
Okay.
And furthermore, just to clarify this legally as opposed to just through common sense and off the cuff, what a reasonable person would do.
Yeah.
One moment. The defendant has no duty to bring himself to trial. The state has that duty, as well as the duty of ensuring that the trial is consistent with due process. That's from Parker. And that is the quintessential answer to your question. Mr. Davis wasn't under an obligation to bring himself to trial. The state was. The state failed on that obligation. The state failed on that duty for 2.5 years.
Okay, so let's talk about, I understand your arguments in regards to the prejudice about what you believe you perhaps could have presented and don't have the ability now, but there's 3 factors under Barker, under the prejudice prong, that we need to look at. So that's there are 3 interests that we should consider. Number 1, to prevent oppressive pretrial incarceration. Number 2, to minimize anxiety and concern of the accused. And number 3, to limit the possibility that the defense will be impaired. So we've already kind of dealt with 3, right? Because we've talked about how you feel your defense will be impaired. Number 2, we can't minimize the anxiety and concern of the accused because I guess from what you're arguing is that he got a call, it was reasonable for him to think nothing happened of it. So there's been no evidence that he's had this anxiety. So we're really now talking about pretrial incarceration, which he's been out. So how do you want me to look at those factors?
So it was pretrial incarceration, anxiety, and what was the 3rd?
It's okay. So it's to prevent oppressive pretrial incarceration, to minimize anxiety and concern of the accused, and number 3, to limit the possibility that the defense will be impaired. We've already talked about the defense being impaired. We've already talked about the anxiety or concern because you already said, like a reasonable person, he never heard from him again, so blah, blah, blah. So number 1, I'm supposed to consider oppressive pretrial incarceration.
So admittedly, I mean, he has been on house arrest for this entire time, for the entire time that he's been, after he was arrested until this moment. But that is definitely not the same as the prejudice caused by pretrial incarceration. I would point out that neither pretrial incarceration nor the anxiety were necessary to award the motion in Doggett. They were not necessary in, they wouldn't have been necessary, they weren't found necessary in Parker, I don't believe. They weren't found necessary in many other cases, Reyes, US v. Reyes, US v. Gregory, US v. Pan.
So sorry, I'm not saying they're necessary, I just wanted to know if you had any comments in regards to that.
I would say this, I would throw this out, and admittedly, before I even get into this, admittedly, this is not much in the way of prejudice, but I think that anybody would, any reasonable person, especially any reasonable innocent person, as Mr. Davis sits here today, would have at least some anxiety from getting a business card on their door from a police officer, getting a call from a police officer, let alone being told that you were at least being investigated. Even that investigation, even if it went nowhere, there might be a little, there's likely to be a little anxiety there for anybody. That being said, there isn't much there, though I would establish that given the level of impairment to the defense.
That's where you're pretty much, I don't want to use the term hanging your hat, but you're saying that the crutch of your argument is in that third interest that the court determined.
And frankly, at the end of the day, Your Honor, I would say that that's the most important of the three elements of prejudice, because there is no constitutional right not to be anxious. There is no constitutional right not to be incarcerated if you are facing charges. There is, in fact, a constitutional right not to have your due process unfairly prejudiced by the state's inaction.
Okay. Is there anything else you'd like me to consider?
One moment, I thought there.
Before you stop, can I read this case I pulled up really quickly, and it's not very long. If you wouldn't mind just letting me read it for a second,
Absolutely.
that you're talking about in regards to the Salgado Romero case. Sometimes I feel like you and I are not reading the same things. So let me read to you something. Assuming that the complaint started the clock for speedy trial purposes, there was a delay of 18 months. 18 months is a presumptively prejudicial period of delay. This period of delay requires the court to analyze the remaining Barker factors. But an 18-month delay is not excessively long and does not weigh heavily in Salgado Romero's favor.
Yes, we weren't comparing to the facts of Salgado Romero. We were citing Salgado Romero for the line on page 520, where it says a negligent delay of less than 20 months requires a defendant to show actual prejudice.
Right, but that doesn't say over 20 months, it's actual.
It at the very least establishes from that point lower. I'm not sure if Salgado Romero specifically states it. I think it's unclarified.
I know, but you represent things to me that honestly are not true. I mean, it clearly says right here that it's disturbing. An 18-month delay is not excessively long and does not weigh heavily in Salgado Romero's favor.
Yeah, and again, we are well beyond, we're a year beyond Salgado Romero's facts. And no, I apologize if
But the way it was presented to me was that if it's 18 months, basically Salgado Romero is saying is if it's over 18 months, then it's actual prejudice, and that is not at all what this case says. Not at all. You have no case that it says around this time period that we're dealing with, it is actual prejudice. You have to show you are at presumptively prejudiced. I just want to make sure, the way I'm reading Doggett, the way I'm reading each case that you've given me, we are still at a presumptive prejudice level. There's nothing that says actual prejudice is just, we just have to say that happened. I mean, I still have to weigh these four factors. Do you agree with that, or you don't agree with that?
Absolutely, absolutely.
Okay.
And what I was saying is that Salgado stands for under 20 months, actual prejudice needs to be shown. I don't know what it is above that. I don't think there is a bright line of when that absolutely cuts off. I apologize, Your Honor, if I was speaking rather quickly, hit my point and then moved on. I certainly didn't need to mislead. I certainly wasn't trying to mislead the court in any way. I think I may have just spoken a little too quickly and moved on from that point a little too fast. It was certainly not my intention to try to bamboozle the court. Nothing to be farther from the truth.
Ms. Cox,
actually, if I could, just a moment.
Okay. No, I'm sorry, I thought that was, go ahead.
No. To establish, the timeline and when is presumptive, or when presumptive prejudice is sufficient and when actual prejudice needs to be shown.
Okay.
I would cite to additionally Barker, In Doggett, they discuss Barker, and they say that the 4 years in Barker was not just sufficiently prejudicial, but they called it extraordinary. And that seems to weigh heavily, or that seems to weigh, you know, if Barker was extraordinary delay at 4 years, we're far closer to that than to a prompt arrest, an arrest of a month, or 2 months, or 3 months. So I'd say, you know, we are admittedly somewhere in the middle there, but I think we're far closer. I think in addition to the presumptive, or the assumed prejudice, or the presumed prejudice, or however we want to word it, the prejudice that you can't necessarily show, but is just obviously there, fits in with the logic that Doggett lays out early on in its case, is the fact that if the alleged victim can't necessarily come down with a certain date or certain time, this case was taking place a month, 2 months, 3 months, a year after these events, that would be highly suspicious. That would at least be somewhat suspicious to a jury. A jury would look at that and be like, well, if this was such a big event, why can't you remember even the month? Which in her initial interview, she can't even remember the month in which she allegedly met Mr. Davis. Whereas now at this point, 4 years after the events, that's far easier for any jury to excuse because it's been so long. So it artificially strengthens the state's case, I believe. And again, that is presumptive. Again, that is not something that we can absolutely prove, but it's also absolutely in keeping with the logic that Doggett lays out for why prejudice to a defendant's case is so hard to show, and why a degree of presumption of the existence of this prejudice is necessary. And I would point out that in the state's opposition, she does compare to the statute of limitations, but I think that Your Honor already established that and already nailed that when you said that you wouldn't be concerned with the investigation time prior to the issuance of the arrest warrant, because they serve very different purposes. They're not analogous to one another. Furthermore, that's not part of the analysis. Comparing a statute of limitations to a Doggett delay is a very different thing, and the Supreme Court precedent that we're operating under right now establishes that we have to consider that Doggett analysis and that 1 year to trigger the analysis, and then more presumption of prejudice as you go along,
Right.
less proof of actual.
So I agree with everything, well, what you just said. The only thing I do want to correct you on though is Barker, when they said it was extraordinary, they found that it was well over 5 years. And I think it's important.
I believe if you go a little further, I'm sorry, Your Honor, I didn't mean to. But I believe if you go down a little bit farther, they say that the delay that can be attributed to the state was 4 years. Because there was part of that time that, in Barker, the defendant escaped for a little while.
Yes.
So that was definitely not the state's fault. And we are.
But sorry, I guess what I'm saying, when you use the term extraordinary, they specifically are talking about the 5 year period, and they use the term right after 5 year period, extraordinary. Then they break down after that and talk about the 7 months, there are 7 months of that period can be attributed to a strong excuse. But I just want to make sure when we're making records, and when we're talking about Barker, when they use that term about extraordinary, it's clear that the length of the delay between arrest and trial, well over 5 years, was extraordinary. And then they go break it down. I guess my point is I feel like we're in no man's land here with this time period. We're not at the 18,
we certainly don't have bright lines.
We're not at the 18 months. We're not at the 5 or 4 years in Barker, and we're not at the 6 years in Doggett. So that's why I'm saying I think the balancing of these factors becomes critical, because we're in no man's land between those two time periods. That's all I guess I'm trying to say, which is why I keep asking to go back to the factors to be considered, which I think that you have done. Is there anything else you want to say in regards to the factors?
That was all I had.
Okay. Ms. Collins.
I agree with the court, there's no bright line time period here in the facts of this case. I do want to speak to a couple of the, well, at least to the deprivation of his defense prong prejudice to start with.
Okay.
As far as the last little bit we heard about a sexual assault victim not being able to reflect a specific date that things happened, that happens all the time. That's nothing unique to this investigation. It's nothing unique to the delay between the complaint and the arrest. So I don't think the court should consider that. In terms of being deprived of these 2 witnesses that have now passed away, defense filed 10 witnesses on their alibi witness list that they were gonna have come in here and testify that, you know, Mr. Davis, well, they still haven't given me the content of that, but obviously that defense is still available to them. So I don't think that inures to prejudice the way it was reflected by defense counsel. I think when we do, I do want to like step back to the time frame too for just a moment. We have a defendant, admittedly, quite honestly, I don't know why they put him up here to say he was intermittently out of town, which weeks, months. I mean, we can't put onus on law enforcement to go over there every day. I don't care whether he has a residence here, but he, by his own admission, has been traveling between Nevada and California for protracted periods of time. So while I do understand the time frame concern, I think that fact has to weigh into how presumptive you are about how negligent Metro was. I mean, I agree they should have gone over there and they should have found him. But when they put him up here to say, intermittently for the last years, I have other people staying at my house and I go down for 3 months, I go for a month, I go for 2 weeks, I have a California driver's license, I represent that I'm a co-resident of both states. I mean,
I think that I would agree with you if we had somebody who said, we kept trying to find him, but we couldn't find him, right? But then, and then the defense gets up there and he says, well, yeah, I was in between Nevada and California, but when I'm looking at the status of the testimony today, they're like, basically, we submitted a warrant and we were done.
well, and unfortunately, the
And I
person
get,
assigned is retired, so, you know, the best I can make a record for today.
Yeah.
So,
but you understand, like, what I'm saying is that
I do.
there's, with Detective Giannone being retired, I guess I can't speculate that he did, we're just left with we don't know. So I understand your point, you're saying it didn't make sense when he got up here and said, well, I was in between places. I would agree with you if we had a detective that said, I was trying to find him, but he was always in between places and we couldn't find him. We don't have that.
Understood, and I don't have that record. I mean, I don't have that information to give the court. Obviously, I would have provided it if I could. That's why I brought in Detective Beck to just describe how that system works, how those warrants are assigned, how they're prioritized, the manpower that's here currently and has been in place for a few years. So, and I don't know what Vasquez says, and I don't know what Salgado says. I don't know what Vasquez says about resources, so I can't speak to that.
Yeah.
But, I mean, you heard the numbers, and that's just a practical reality.
Yeah. So, in regards to the length of the delay, you talked a little bit about the prejudice.
Well, in terms of the I don't think there's any prejudice to his defense. And I mean, this is the same type of defense that would be garnered in any sexual assault case where there's a delayed disclosure. It's not unique to this case because there was a delay. So I think the record needs to be clear that, I mean, we have delayed disclosures in sexual assault cases all the time. We have them years after the fact. And we are required to prove a time frame, as this court well knows, not a specific date. So that prejudice that they speak of doesn't uniquely come from the facts of this case. I mean, that's any delayed disclosure sexual assault case. So I don't think that should weigh in favor of more prejudice to him. Do you have a specific question for me?
I'm just trying to go back and forth in regards to that, because as I was reading the motions, that was the first thing that came into my mind. Quite honestly, with the defense, I'm like, late disclosure sex case, it happens all the time. But in a way, I kind of see what defense is saying in regards to, well, everybody in this room can all agree, having done as many sex cases as we all have, that's a common denominator in sex cases. The Doggett analysis, though, doesn't really give us room, I don't feel like, to consider that, because it's more saying, let's look at this case, and in this case we have a disclosure in 15, and he could have been arrested in 16 and handled that matter, you know? So while, yeah, those issues happen all the time in sex cases, do you think that the Doggett analysis allows us to consider that?
the way it was presented here today, I don't think it should even come into the Doggett analysis. Because he presented it as that victim, because this case is old, that victim should have known dates and times, ergo my client can't defend himself. That has nothing to do with Doggett. That's every delayed disclosure timeframe sex case, and I don't think that fits into Doggett. That's just the way I see it. Maybe I see it differently.
No, I mean, I think it's I think it's an interesting part. Sex cases are just their own unique beast with late disclosures and things like that. When I look at this, I wonder how that affects the Doggett analysis, quite honestly.
And I guess I see it as it shouldn't become part of it. It should be considered. I mean, if this were a situation where they hadn't noticed 10 alibi witnesses and they were coming in here and every viable defense I have is gone due to the passage of time, then that's one thing. But that's not what we have here. They have witnesses. They have 10 strong people from Nevada and California. So I don't see that as dispositive.
Okay.
And as far as anxiety, I mean, the court was correct. There was nothing in the record that Mr. Davis was anxious or worried about, a case hanging over his head. I mean, quite honestly, he's been through the system before. He's dodged the bullet a few times before, so.
Objection.
Well, we're talking about this defendant in this circumstance. I didn't interrupt you. Can I stop? But there's nothing in the record that he had any particular anxiety about what was forthcoming. Obviously, no incarceration.
What is your position in regards to, does incarceration mean just behind bars? Does pretrial incarceration also encompass things like house arrest, monitoring, that type of stuff?
Well, he gets credit for that monitoring in some departments, but some departments consider that a period of incarceration. And I mean, if his short detention on house arrest troubles the court, then you can remove it.
No. I just want to know if you, whether or
it is
not
a
that's
restriction
something, a restriction on
It is a
something that should be
restriction on
considered.
movement. In light of the circumstances and the charges, I think it's a very minimal restriction on his movement. Given what I know about his record and his past, I think it's a very minimal restriction under these circumstances.
Okay. Let me look at any other questions I had. So this whole thing has to do with like a speedy trial, right? We have talked about that we believe he asserted it. Do you think that the fact that you were ready for trial and the defense requested a continuance, the defense did not request a continuance, you requested continuance due to a late alibi file which necessitated a continuance. Do you think that should be considered in regards to an assertion of a speedy trial?
No, because I don't think you can create your own error and impute the fault of that to the state. I don't think you can file late alibi, file late motions, force the state to continue under the rules, and then cry foul and prejudice when you don't get your trial this week. I mean, you can't.
No, so I'm saying, do you think that should be considered against them when, look, you're saying you asked for a speedy trial, but when it came down to you getting your trial, you were the reason it got continued?
Well, absolutely, I think it's on them. It's not on the state. And I guess I'm just saying it in the reverse, like it shouldn't be imputed to the state that we're somehow violating his speedy trial right based on, how the preparation for trial progressed. I mean, that is on them. I mean, we had phone conversations last week. I would have done my best to have those people interviewed. It just was absolutely impossible at 4:45 on a Friday. So, I mean, that is on them, and I think that should come out of the analysis as far as prejudice goes.
Okay. Anything else from you?
Not unless you have anything for me.
All right. So, I'm going to give you the last word, Mr. Mayor. Ms. Mealy, you coming to talk or what?
With my deference to my colleague, I would just like to make a very brief reply because there's several points here that I think none of you quite touched on yet. No, I promise I'll be very brief. Number one, you should grant the relief. We have actual prejudice. We have actual prejudice not through delay disclosure, but through delay of action. The government's negligence is unambiguously clear. 5,000 warrants a year, we can serve 600. They have a systematic deficiency of 3,400 warrants a year.
I'm with you on negligence, but just tell me what the actual prejudice is.
The actual prejudice is who was living in the apartment. Now, I did the preliminary hearing, my colleague did not. Every allegation of wrongdoing from this teenage prostitute occurs in an apartment. Every one of them is in the apartment. Who was in the apartment, when they were in the apartment, because he said, and everyone seemed to miss it, that there were people staying at his apartment on a regular basis. There would be people who could have said, that's not true, I was there the whole month of October, there was nobody in the apartment. Now, that's the practical problem with this case. The two gentlemen who, God bless them, have passed, certainly causes us prejudice.
They're not people at the apartment, though.
They were down there, they could have.
They're people in California.
That's the problem. The delay has made it impossible for me to ascertain the timeline. If they'd gone and served this warrant in October of 16, we'd have been sitting here, this case would have been over with, and we'd have been known who was in the apartment, what the alibi was, and where Mr. Davis was at the time in question. But that can't be done now because of the passage of
Wait,
time.
time out, I want to be clear though. The two people that you're saying are dead, those were people in California.
California.
Correct?
Mr.
Not in
Davis.
Nevada in the apartment. Just,
The-
I want to be clear.
Oh, absolutely. But there are two different potential alibis here, all of which
No, I
are...
get it. That there's someone in the apartment that did it, and that there was people in California that could have said he was in California.
Right,
I got it.
or someone, or maybe for whatever reason. And the other thing is now, negligence on this particular facts, because the facts are unique. Number one, he's a personality. Type him in, have your staff type him in, see how many names pop up on Google.
No, I think we all agree he was negligent.
So,
We're there.
okay, so, now, here it was, now 2 years. All he had to do was literally get in the car, drive 2 miles, the guys had the same apartment. The state's on notice is exactly where he lives. You have the district court to take judicial notice of his jury summons. That's where he lives.
Agree, but that all goes to negligence. I agree with you. It was completely negligent. Go to the house, pick him up. But where we have to talk about though is length of delay and prejudice. That's where it all stands.
The length of delay goes into passive presumption, and actually, we've demonstrated actual, not just presumption, we have actual prejudice. And that's, and all of us handle lots of cases. The constitutional due process rights attached to individuals, in this case is Mr. Davis, and his rights have in fact been violated sufficiently that he's entitled to relief.
Okay.
Thank you.
All right. So here's, Mr. Davis, you better talk to your attorneys because that's why you have them there.
I have one question.
You can't ask questions.
They could have called me, though, okay?
Okay. They know, the judge knows the date, your phone number.
They could have called me, though, okay?
Thank you. The judge is aware that, they wanted me to emphasize the fact that they had your phone, his phone number.
They would have called me.
Excellent.
But just to rebut Mr. Mueller, though, it was my understanding that the police officer stated he did call him, that the defendant stated, I don't want to speak anymore about this investigation.
That was before the arrest warrant, before the.
Oh, yeah, no, I know
attached. Yeah. Furthermore, I think a lot of people who have arrest warrants probably don't want to talk to the cops, and it doesn't seem that there.
No, but he's saying that I would have called, if they would have called me, I would have come in.
Mr. Davis's point, and it's a very good one, is simply that the record is even negative or naked as to anybody even trying to call him.
I get the thing that I think we're defense and the court are on the same page is it was negligent. I'm with you guys. The fact that you take a warrant and you just put it in NCIC and on a sexual assault charge and you never go and try to go get somebody, I'm with you, it's negligent. But where the crux of this analysis is the length of the delay and the prejudice. So here's the deal. In regards to the length of the delay, which is the first factor, we're really in no man's land here, right? So we're post the 1 year, which tells us, it doesn't tell us it's actual prejudice. It tells us we need to go into the 4 factors. But we're not at 5 or 6 years where they're like, look, I mean, that's clearly basically extraordinary, or, they use the term. Basically, the longer the time goes, the closer we get to this just being absolutely ridiculous and prejudicial. So the way I look at this is because the length of the delay is in no man's land, we need to look at each of the other factors. So the second factor is reason the government, well, if you want to go back, to the first factor is the triggering mechanism. So I've already said we're past the year, so I think we go into the factors. So then let's look at the length of delay and that the reason the government assigns to justify the delay. I don't think it was done in bad faith. I don't think there's been any evidence that shows it was done in bad faith. I think it has to do with negligence. So negligence is shown while there's a balancing test that needs to be done. I agree with defense that it comes down on the wrong side, right? Or the side that shows, hey, what's going on here, it is not okay. But I also think that it does state that the court can consider, and it states, over a more neutral reason such as negligence or overcrowded courts should be weighed less heavily. Number 3, the defendant's responsibility to assert his right. I think he has asserted his right here. I recognize that he did know an investigation was ongoing, but I don't think that puts the onus on him to go and figure out when he's going to be arrested or when that's going to go down. So to me, the most important factor here that the court needs to consider, and I think that this all comes down to prejudice here in this case. And the court has identified 3 such interests. To prevent oppressive pretrial incarceration, I don't find that happened here. To minimize anxiety and concern of the accused, I have no evidence in front of me, including testimony of the defendant, that there was anything about this anxiety. So what it comes down to is the possibility that the defense will be impaired. That really is where I feel like my entire analysis. I've gone over the facts of this case. I've read Barker, I've read Doggett, at least 5 to 6 times. And so when I look at the prejudice in this case, we're looking at how many years is it? 2 years and how many months? 10, 9, what is it?
Over 6.
2 years and 7 months?
It was between the initiation of the case or the issuance of the arrest warrant and arrest was over 2 years and 6 months. It was 2 years, 7 months.
2 years and 7 months.
Okay, so 2 years and 7 months. So when I hear about this prejudice, what the defense is telling me that they have these 2 individuals that have now passed, and they could have given us an idea of where the defendant was when he was. The issue with that is the defendant, per the defendant's own testimony and with the defense, is a very public person, and if you go and Google him, like he says, it gives you where he was, when he was, the amount of money that he made, and then the other thing is regards to the delay to get the video for like Fatburger or somewhere in regards to where the victim was, where they met those individuals. I don't have any testimony. I think it's common knowledge. We all know that a lot of those videos get taped over. I think it's like some it's 48 hours, some it's 7 to 10 days. So when I look at the analysis in its totality, I was really looking to see what was going to be presented in regards to prejudice. I don't think we're far enough along the line where I can just say actual prejudice has been suffered. I think I have to do a balancing test. And here I see 2 witnesses that have passed away, but I also see someone who, fortunately and unfortunately for him, is a very public person, and that you guys can show where he was when he was. And so I am going to deny the defendant's motion on that basis. I recognize that the Supreme Court heard arguments on a case very similar to this in the Anunza matter. I think it was last week, and I think we're going to get, hopefully, further clarification in regards to where the Supreme Court stands. So I'm going to deny this without prejudice pending that decision. And if that decision gives us more clarity, then I'm happy to hear this and reassess this again. But as it stands right now in regards to the prejudice that I'm looking at, where I believe the crux of this argument is, I'm not seeing the prejudice, and that's the reason why it's denied. So Ms. Collins, I'm going to ask you to provide an order in regards to the factors that I just discussed.
Yes, ma'am.
And if you need a transcript or jabs for my ruling in order to make the one thing that I've been having an issue with lately is when it just says like defendant's motion is denied, because that makes an insufficient record for the Supremes if I'm going to get appealed to make a ruling on. So I would just ask.
Transcript or jobs, whichever is easier for the court, just so I articulate it the same way.
Yeah. So I think jabs is quicker and easier. So if Deanna, if we could provide a copy of the jabs today of just like the last 5 minutes of my ruling. To both the defense as well as Ms. Collins, so an order could be done.
Thank you, Your Honor. Can the order reflect
without prejudice, so we can, after the Supreme Court
Of course.
grants? Thank you.
Yeah.
And I'll be a child, so it might be a couple days.
That's fine.